Ready? Start. In the wake of the finding that the above mentioned documents have not been fraudulently obtained or have not been manipulated, treating the said documents to be duly executed and as yet genuine, one thing is clear, that the plaintiff respondents is in a settled possession of the suit property, at least in part performance of the agreement, which cannot be disturbed or disputed by the transferor, stop, that is, the defendant appellant, stop para. At the cost of repetition, the suit is for eviction of the defendant appellant from the suit premises and for recovery of men's profits on the ground that after the defendant appellant has parted with the possession of the property in favor of the plaintiff respondent in part performance of the agreement, he has no right to disturb his possession, stop. He is simply a licensee, and the license having been terminated, he has no right to remain in possession but to restore possession to the person having rightful possessory title over it, stop para. It goes without saying that the power of attorney executed by the defendant appellant is of no consequence, as on the strength of said power of attorney, neither sale deed has been executed nor any action pursuant thereof has been taken by the power of attorney holder which may confer title upon the plaintiff respondent, stop. Non-execution of any document by the general power of attorney holder consequent to it renders the said general power of attorney useless, stop para. Similarly, the will dated 10/4/2002 executed by the defendant appellant in favor of the plaintiff respondent is meaningless, as the will, if any, comes into effect only after the death of the executant and not before it, stop. It has no force till the testator or the person making it dies, stop. The said stage has not arrived in the present case and, therefore, even the aforesaid will in no way confers any right upon the plaintiff respondent, stop para. In connection with the general power of attorney and the will so executed, the practice, if any, prevalent in any state or the High Court, recognizing these documents to be documents of title or documents conferring right in any immovable property, is in violation of the statutory law, stop. Any such practice or tradition prevalent would not override the specific provisions of law which require execution of a document of title or transfer and its registration so as to confer right and title in an immovable property of over rupees 100 in value, stop. The decisions of the Delhi High Court in the case of Veer Bala Gulati versus Municipal Corporation of Delhi and another, following the earlier decisions of the Delhi High Court itself in the case of Asha M. Jain versus Canara Bank and others, holding that the agreement to sell with payment of full consideration and possession along with irrevocable power of attorney and other ancillary documents is a transaction to sell, even though there may not be a sale deed, are of no help to the plaintiff respondent, inasmuch as the view taken by the Delhi High Court is not in consonance with the legal position which emanates from the plain reading of Section 54 of the Transfer of Property Act, 1882, stop. In this regard, reference may be had to two other decisions of the Delhi High Court in Imtiaz Ali versus Nasim Ahmed and G. Ram versus Delhi Development Authority, which inter alia observe that an agreement to sell or the power of attorney are not documents of transfer, and as such the right, title and interest of an immovable property do not stand transferred by mere execution of the same, unless any document as contemplated under Section 54 of the Transfer of Property Act, 1882, is executed and is got registered under Section 17 of the Indian Registration Act, 1908, stop. The decision of the Supreme Court in Suraj Lamp and Industries Private Limited versus State of Haryana and another also deprecates the transfer of immovable property through sale agreement, general power of attorney and will instead of registered conveyance deed. Stop para. Legally, an agreement to sell may not be regarded as a transaction of sale or a document transferring the proprietary rights in an immovable property, but the prospective purchaser, having performed his part of the contract and lawfully in possession, acquires possessory right title which is liable to be protected in view of section 53A of the Transfer of Property Act, 1882. Stop. The said possessory rights of the prospective purchaser cannot be invaded by the transferor or any person claiming under him. Stop para. Notwithstanding the above, as the plaintiff responded admittedly was settled with possessory title in part performance of the agreement to sell dated 10/4/2002, and that the defendant appellant has lost his possession over it and had acquired the right of possession under a license simpliciter, exhausted his right to continue in possession after the license has been determined. Stop. Thus, the defendant appellant parted with the possession of the suit property by putting the plaintiff respondent in possession of it under an agreement to sell. Stop. The plaintiff respondent in this way came to acquire possessory title over the same. Stop. The defendant appellant as such, ceased to be in possession of it as an owner, rather occupied it as a licensee for a fixed period which stood determined by valid notice, leaving the defendant appellant with no subsisting right to remain in possession of the suit premises. Stop para. In view of the aforesaid facts and circumstances, the plaintiff respondent has rightly been held to be entitled for a decree of eviction with men's profit, we do not find any error or illegality in such a decree being passed. Stop. Accordingly, the appeals lack merit and are dismissed with no order as to costs. Stop.